Greetings. My name is Tanya Ward Jordan. I am an injured federal employee due to workplace discrimination and retaliation, and I'm also the president of the Coalition for Change, Inc. C4C. Today, I want to talk to you about the story in brief about Anthony Perry, who challenges the Merit System Protection Board. I put together this brief PowerPoint, although the litigation is long and unending, and I have entitled it The Unsettled Settlement Agreement, a Whistleblower's Jurisdictional Plight. My friend and fellow activist, Anthony Perry, challenges the Merit System Protection Board. His mixed case complaint really concerns the proper forum for judicial review of a severe employment action taken against an employee within the scope of the Civil Service Reform Act when an employee ties the action to bias due to breach of a federal anti-discrimination law. In this case, the underlying question becomes, what court will hear a plaintiff's challenge to a federal agency settlement agreement signed under duress? Anthony Perry's case really exposes how the government complaint system removes whistleblowers from the workforce, concocts settlement agreements to bury valid discrimination claims, and also how it fails federal workers who seek timely and fair justice through the Merit System Protection Board. I would like to share a bit about the beginnings of this scenario. It goes long, so I've included some links in this PowerPoint. But let me just give you a brief digest of it. Anthony Perry joined the U.S. Commerce Department Census Bureau in 1986. And for 29 years, he maintained a flawless disciplinary record. Now, it came a time where he suffered debilitating arthritis, and his supervisor gave Anthony Perry informal accommodations due to his condition. He was able to take breaks, walks to relieve some of the pain, and complete work after hours. There came a time where Anthony Perry once again complained of discrimination in Census Bureau. This time he raised his complaint to the Bureau Director. Shortly thereafter, his flexible schedule ended without notice, according to court records. A supervisor erected a new policy and required Perry, along with lower staff members, to sign an attendance log. Now, Perry, who was a GS-14 supervisory position, he questioned the new policy that no other GS Supervisory 14 had to follow. Census officials swiftly moved on Anthony Perry after he questioned the new policy, and that is quite the norm in the federal government. Should you question a policy that reflects disparate treatment, or if you expose unlawful actions, they will move swiftly on an employee. In Anthony Perry's case, they claimed that he had failed to sign this new attendance log, been away from his desk, but they negotiated with Anthony Perry and said, in lieu of firing, if you were to sign this settlement agreement and retire early and drop all EEO complaints against the Census Bureau, including the 7 pending before the EOC, they would not reflect his exit as termination. Anthony Perry, a dedicated civil servant, decided to sign the settlement agreement. He did so under the threat of termination and over risk of losing his retirement pension. He signed the agreement with his employer, the Census Bureau. In 2012, Perry retired, and at that time he filed a MSPB appeal. He claimed that Census discriminated against him, retaliated, and falsified charges against him, as well as forced him to retire via settlement agreement. The case went before A.J. Turbot, who asserted that retirements are presumed voluntary. Therefore, MSPB lacked the authority to review Perry's claims arising from any settlement agreement. Anthony Perry went on to appeal A.J. Turbot's ruling to the full board, and the board remanded the case back to Turbot. And again, Turbot raised the jurisdiction issue. He refused to hear Anthony Perry's claim of a settlement agreement signed under duress. So Perry, he appealed a second time to the full board. And after this second appeal, the board on August 6, 2014 affirmed the AJ's ruling and wrote, "It cannot hear an appeal on its merits because it lacks jurisdiction to do so." After MSPB's final order refusing to hear Perry's claim, he took his complaint against Census Bureau to various courts, where each time the court asserted they had no authority to hear Perry's claims. Perry appealed to the U.S. Court of Appeals for the D.C. Circuit. And the question that went before the circuit was, which federal court has jurisdiction to review the MSPB's dismissal of Perry's mixed case complaint? Two possible answers exist. Is it the federal circuit or is it the federal district court? That is the determination that had to be made. Now, Perry, through his court-appointed counsel, argued that the jurisdiction to review the board's decision lied with the federal district court. However, the board and the government argued, no, it's the federal circuit. The court ruled with the board and sent the case over to the federal circuit. Once Anthony Perry got before the federal circuit, of course, the federal circuit docketed the Perry v. MSPB case, but it also granted Perry's motion. And what was his motion? Anthony Perry had motioned he wanted to suspend the proceedings until the Supreme Court had decided which court should hear the case. Very few people, agreed parties, ever get before the Supreme Court, but Anthony Perry did. And in 2017, he won and set precedent in Perry v. MSPB. Justice Ruth Bader Ginsburg authored the court's opinion at the time, and she stated that because Perry's complained of a personnel action serious enough to appeal to the MSPB and alleged that the personnel action was based on discrimination, he did in fact bring a mixed case. And the court remanded Perry's case in 2017 back to the United States District Court for the District of Columbia. Unfortunately, Perry's case stalled there under the presiding judge, Judge Tanya Ward, for over 5 years. 5 years later, on September 30th, 2022, Judge Chutkan issued an opinion. And she opined, unfortunately for Perry, this court will not reach his discrimination claims either, but instead will affirm the Merit System Protection Board's decision dismissing his claims for lack of jurisdiction. Anthony Perry, who had largely operated pro se, was dismayed. It took Judge Chutkan 5 years to issue an opinion that conflicted with the Supreme Court's ruling that placed Perry v. MSPB under her authority. Therefore, on November 16th, Anthony Perry, through a court-appointed lawyer, was able to get a amicus brief filed by Nathaniel Zielinski. And the brief cited, District Court erred when it declined to consider Perry's discrimination claims de novo. The brief makes two arguments. The first, District Court must consider claims de novo. And a second, the Merit System Protection Board should have held an evidentiary hearing in Anthony Perry's case. Oral arguments are pending before the U.S. Court of Appeals for the D.C. Circuit. Meanwhile, Perry lifts the quote credited to the legendary Paul Robinson. The answer to injustice is not silence, but ending injustice. In closing, as the president of the Coalition for Change, Inc., C4C, I have spoken to many federal employees who have suffered from workplace abuse. Yet, the Merit System Protection Board has failed miserably to protect the many who report prohibited personnel practices. As in Perry, the MSPB often will refuse to hear how officials manipulate personnel systems to set up civil servants, wrongfully charge them, and bind them into signing roguish settlement agreements that require these brave whistleblowers to drop valid claims against the government to avoid termination and to protect their future and well-earned retirement.